So good afternoon, everybody. Thanks for attending our next panel. Topic of this panel is AI privacy and data protection. Different to the other panels we had before, we will not have separate presentations. Instead, we would love to give you or to provide a discussion, a more lively discussion about this very difficult but very interesting and challenging topic. And we invite you to ask questions at any time, but in any event, we will reserve some time at the end of this session for you and give you the option to ask questions either related to AI privacy or data protection in general. We will try to cover both and very much look forward to this panel. Quick introduction of myself. My name is Conny Ewald. I'm a partner at Osborne Clarke. I'm the head of Osborne Clarke's Interactive Entertainment Group in Germany. Coming from Germany qualifies me to do a panel on privacy, I guess. This is where we are now. So we would like to kick off the panel with a short introduction of all of you. Maybe you want to start?
Okay. Hello. Hello. Hello, my name is Daria Firsova. I'm senior counsel and I'm at Wargaming. We produce and publish video games, and I deal with intellectual property and data protection, and now in the GDPR team.
Yeah, hello, I'm Willy Johan from the Activision Blizzard International team. So I do several things, especially data protection those days. Apparently it's a big topic. So internationally, so I lead the privacy program for Activision, and I do also a lot of commercial work, some regulatory work, and some esports as well.
Hi, I'm Paulina Smukovska. I am an alumna of Queen Mary, which makes me very proud to be here. I used to work for Wargaming, so that's my games background, and now I work as a data protection officer at Avito, which is the largest classifieds platform in Russia.
Hi guys, my name is Rafał Kłoczko. I'm heading the legal team in CD Projekt. We specialize in role-playing games. We made the Witcher series with The Witcher 3 Wild Hunt. I'm very happy to be here because this is one of the rare occasions when I can wear a suit. So I finally had a chance to take it off my closet because it's prohibited to wear a suit in CD Projekt. So I'm also happy to have this.
You're the best looking man on the panel, definitely. Fantastic. So hopefully we get a lot of practical insights from really qualified panelists, all working in the games industry, which is absolutely fantastic. Warm welcome and thanks for attending. Yeah, let's kick off this panel and let's give it some thoughts. We have, this morning we have learned a lot about fascinating AI applications, and maybe to sum it up, what does AI mean from a data protection and privacy perspective? AI means the collection of a lot of data, enormous amount of data, and based on the data, the ability to make automated decisions, predictions, etc. This is one of the key outcomes, I would say, of this morning. And this gives us a lot of headaches, of course, from a privacy and data protection perspective. The GDPR, this monster, is only less than 2 months away. Before we start talking about the GDPR and its implications, can I ask you who's ready with the implementation? Raise your hands, please. Oh, I've never met before someone who can say he's ready or she's ready. So congratulations. And one of the biggest headaches when you are in games and deal with AI is probably what does mean AI with respect to the GDPR, and this will be one of the decisive topics. Why is that? Let's think of the relevant provisions in the GDPR when dealing with AI, and for those of you who are not dealing with the GDPR on a day-to-day basis, let me read out what Article 22 is saying about automated decisions and profiling. That is the most relevant provision, I would say, with respect to AI. And this provision, and according to Article 22, says any person has the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her, or similarly significantly affects him or her. This is what the GDPR is saying, and this is probably the key article that is giving us most headaches from a regulatory perspective. Before we dive into that and what that means for AI concept, and whether this is an AI killer, as you can sometimes read it on the internet, let's stick to the first aspect of AI, the collection of large amounts of data. And the first question to the panelists is, when you think about your companies, what kind of data are you collecting? Why is the industry so keen to collect as much data as possible? What are the actual practical applications for AI within games companies you are working for? Daria?
Yeah, I think that even before we go to Article 22, we probably should think about what is personal data under the GDPR and about the broader scope of personal data under the GDPR. And the main question for us here as a gaming company was whether game statistics should be considered as personal data. Because as soon as game statistics is considered as personal data and looks like it should be under the definition of personal data, the amount of data that we collect and analyze becomes enormous. And why we analyze it is mainly because we need to properly perform the contract and provide our users with the services we need, and at the same time to understand who is our user, so that to provide the services which are of most interest to him. So I think that we do collect lots of game statistics, we do collect lots of information that would help us to understand whether our users comply with our in-game documentation, whether they don't infringe, don't violate rights of our other users, and whether they make any frauds within the game. So this is the main topics, probably.
So in other words, you distinguish very carefully between the kind of data you are collecting, and not necessarily all data is personal data. There are a lot of anonymized data, and one application is fraud prevention. Willy, how about Activision and the AI applications you're dealing with?
Well, I would like also to stress out, on top of the definition of personal data, that collecting a lot of information is not typical for video games. So it's all the companies, like from traveling to healthcare, etc., that collecting a lot of information to better know their users and to deliver a more tailored service to the user. So this is exactly the same way that we are collecting information to improve our games and to deliver better content to our players, so to satisfy them. And obviously to help them to buy some extension and stay engaged with our games. As just mentioned, so we are collecting obviously the data generated by the game itself. So it's important to have some technical information from the game, first to detect bugs. It's very important to us to correct bugs. So we have a lot of new input into the games, and so we can detect when a player is stuck at a level or he cannot open a door, etc. So having this data back to us will help to resolve this issue. We can. So that's for technical data. So this is the very important part. For the second part, more personal and behavioral information. So what do you like to play? Which kind of game you play, or which kind of level you prefer to go? Which kind of you prefer a campaign mode, or an adventure mode, or just fight between two person, for example. Knowing that will help us to better deliver and suggest content that you would like within our environment. So let's say you're a very hardcore gamer and a shooter game, and you love to shoot with pink guns. And therefore, so knowing that you like pink, we can try to offer you a new gun, which is pink as well, instead of offering the yellow one. And so you should be happier having a collection of pink guns, because this is your favorite color, as we detected that.
For some reason, I'm I'm just imagining how to play Call of Duty with pink guns, but we can discuss that separately.
Well, well, you can absolutely. You will be probably an easier target, but.
So Paulina.
I should probably skip this one because I'm not working for a games company, and I'll join on the data protection aspect.
Yes. So Raphael is from.
I'd say, okay, maybe I share a bit of my personal experience. I joined CD Projekt around 3 years ago, so just before The Witcher 3 released, and it was the miraculous, fantastic life, because we just created a game that didn't use any data, and on the legal side, we were ideal. We just created the game, sold it to the customers. We didn't need to interfere in any legal way. But as we see the market is moving, and everyone said just that before, is moving more and more into the service-based way of playing and offering and enhancing the way how the user can play the game, trying to find the best ways so that the player will be happy. Because most of the stuff that we're doing with data or analytics is just to make the player happy. This becomes the bigger and bigger problem or issue on the legal side, especially in the GDPR perspective. We personally, as CD Projekt, we try to use the minimax rule. So we try to gather as little data as possible, so we don't have a chance to identify given users, and to as little as possible to attain our objectives. So this is the main way how we work with data. However, for example, because I don't want to tell the same stuff that you said, guys. But of course, analytics, blah blah blah, ping guns. We also have that, of course. But for me, one of the quite interesting issues was with the motion capture, when we actually thought about motion capture as biometrical data, which is under very, very specific regulations of GDPR, because we record the way people behave, we keep this, and this is a bit different approach than a traditional way of thinking, that name, surname, and other issues. So to sum up, usually we try not to collect data if it is only possible, personal data. But of course, new issues emerge together with the fact that the definition of personal data is very broad.
Yeah, perfect. Thanks for sharing. There were a lot of applications for AI already. And you already touched on the topic how to collect data actually, and you call it the minimax principle. Willie, I was wondering whether you have any thoughts on how to collect best data. What is, from your point of view, the best practice when collecting data and communicating to the user? And I would love to hear your view as well on that.
Well, it depends which data we are talking about here. If we are talking about non-personal data, well, you're playing a property that we own. The data, the technical data, we own it as a publisher, so this is already our data, so we're not like properly collecting data, so extracting new information from someone. When we talk about personal information, this is not a proprietary information because it belongs to the individual as a part of his personality. So you don't own copyright, for example, on personal data. So there is obviously obligation under the current legislation in Europe. This is the same in the US. This is the same anywhere. So it's about transparency. And so you need to tell what you do, to explain what you're doing and what you plan to do with the data you're collecting. So this is quite obvious. This is what any citizen will expect. And obviously, this is the best practice. On top of the collection, there is, I think, something very important. It's if you haven't said that you will do something different, so you cannot do it. So you can only collect and use the data for what you disclose to the user. So it's beyond your question, but this is well, this is not the best practice. This is the law. Yeah.
A little bit, yes. So besides probably transparency and data minimization, the principles that we are trying to follow as much as possible is purpose limitation. And when we are collecting data, we are, first of all, I would say, thinking about whether indeed we need this data to meet this particular purpose, and whether our players understand that now we may be collecting their data for this particular purpose. So when we are collecting their game statistics, we assume that it's quite clear for them that we are collecting it. When we are collecting their behavior on our websites, again, it's our assumptions that we are doing that. Or when they participate in a competition, we think that we are collecting their data. What we try not to do is to collect data for one purpose, for example, to collect data for their participation in a competition and to use it further, for example, to help in promotion of our other games or for games that are published by our other partners. So that it's always very easy for us to explain to our user where we got this data and why we are using it this way. And if we want to use it for another purpose, we go and get consent or try to find another reason to use it.
Rafael, anything to add from your perspective?
I can just add one more thing that just came to my thought about this. The real problem that sometimes happens is when you don't want to collect the data, but the data comes anyway. Yeah. This happens many times with support. When we have like support groups, people fill out their forms and from time to time receive messages like, hello, my name is John Smith, I am dying on this and this disease, this is my address, this is my security number, and our support gets totally pale and says, hey guys, what we should do with this? Because we didn't want any of this information, but actually people are sharing with this. So I don't know how it goes with you guys, but in our case, we have a lot of people sharing their personal stories and really stuff that we don't want to see. So from time to time, the problem is not that we collect the data because we want to, but this is just people jumping, throwing data at us and saying, hey, take this. And we're like, no, please don't give it to us.
Yeah, you're touching on one of the most discussed topics right now under the GDPR, so it's probably not an issue of collecting the data, but what to do with the data that you did not want to. Exactly. And that you need to address that in your deletion concepts and stuff like that. But I think absolutely right and valid point. The things that you, Willy, and Daria mentioned are really applying now to the new GDPR principles. Yeah, being very transparent about what you're doing, clear communication, and what you said. I think this is very important to describe exactly the purpose of data collection and processing, and stick to the purpose, which is an even more important requirement under the GDPR these days. Before we turn to the actual implications of the GDPR. And what it means for AI applications and automated decisions. Let's turn to Russia, this particular data protection regime. Can you give us some insights, Paulina, what a company needs to observe when profiling users in the Russian market?
Thank you. I will probably try to answer this question, very specific question, by giving a very broad context. Because of the peculiarities, it's necessary to see how Russian data protection regime even came to be where it is now. So Russia is a signatory to the European Convention on Human Rights, because Russia is a member of the Council of Europe. So Russia as a state is obliged to guarantee the right to privacy under Article 8 of the Convention. However, there is no word in Russian that would equal to the word privacy in English. And the discussion of protecting privacy or personal data as such never really came to light until 2000s, actually. So, you know, in the 90s, when Europe was busy developing the principles for data protection, and adopting the directive of 1995, Russia had other priorities to take care of. And it wasn't until 2006 that the Russian law on data protection was adopted. However, even then, as many claim, it wasn't done to necessarily protect the rights of individuals, but to facilitate trade with the European Union. And these claims were not unfounded for two reasons. And firstly, if you look at the text of Russian personal data law, you would see it's quite a copy-paste of the directive. So not too much thinking seemed to be involved at that time. And until 2015, there was very little friction with the law. The changes that were made to it were very minor, and the case law, if it existed, was quite low-key. What happened in 2015 was the infamous data localization amendments, and I'll go back to it in a bit to see why this really matters for profiling. What happened in the meantime between the 1995, when the Data Protection Directive was adopted, and the 2006, when the Russian similar law was enacted, is 2002 e-privacy directive. And it's really important because it created this legal regime for online identifiers. And at that time, technology did not necessarily permit to use online identifiers to identify an individual. So there was a separate regime, and there was data protection under the directive coexisting. And by 2015, when the Russian major changes happened in data protection, technology did allow to use IP addresses, to use MAC addresses, and data from the cookies to identify the individual. So what happened is that kind of these two regimes in Europe merged, while in Russia, there was still just the data protection regime without the online identifiers or cookies, notices, or any of that sort. So the Russian authorities were in the limbo of, okay, so what do we do now? Do we create a copy-paste of the e-privacy directive or a new sort of regime to cover that area of big data? Or do we stretch the personal data to also cover online identifiers? And to this day, there is no actual answer to that. So the Russian Data Protection Authority does state that online identifiers are recognized as personal data. However, there is no real enforcement. And it's my assumption that there are two major reasons for that, because it would not be possible to comply. Well, first of all, and now we go back to localization. If all online identifiers, and let's just take as an example data from the cookies, from persistent cookies. If all the data were to be collected, systematized, and stored in Russia, how many companies would actually be able to comply? And localization law, just to give you a broader context, is a requirement that all personal data of Russian citizens is initially collected within Russian territory. It can be passed on after it is collected in Russia. However, that's the starting point. So Google Analytics, questionable, right? Because Google does not have data centers in Russia. Well, that's a problem number one that I see. And problem number two is if we concede that online identifiers or a user profile created from big data is personal data, then further inference that enriches the profile is also personal data that is now created outside of Russia, right? So basically, all profile enrichment has to take place in Russia, as long as we deal with the data of Russian citizens. And that also seems to be quite problematic. So that would be the course of stretching personal data regime to online identifiers and other similar technical data. It is likely that there will be a separate law, and the discussions of it have been going on for a while. So we're not expecting it to be adopted anytime soon. However, it's a possibility, and it would be a law regulating big user data. Possibly localization requirement will be replicated there, but we'll see how that goes. There is this whole concept of digital economy that is now incentivizing a lot of legislative developments in Russia. So there might be a much broader revamp of IT legislation, and online identifiers being personal data will be the least of our problems. But that's where we stand now.
Cool, thank you. And just to clarify that, when is a foreign company subject to Russian laws and the laws you're just describing?
Well, first of all, targeting Russian market, and second of all, establishment within Russia. In that sense, Russian rules are quite similar to the European approach.
Okay, thank you. Yeah, speaking about Europe, and let's turn back to the GDPR thing. Article 22, our favorite provision in the GDPR. I've just read out the language of Article 22. And if we have in mind what AI means, and you gave a lot of wonderful examples where you are already using AI applications in games, is Article 22 GDPR now the AI killer, as it was called when we first read the new GDPR, or is it possible to apply AI solutions in compliance with the GDPR rules? What's your view on that, Darja?
I would say it will be very complicated for AI to comply with Article 22. What we are trying to do now, and I think that most video game companies are trying to do the same, is to argue why your particular activity is not falling under Article 22(1) of the GDPR. So the test is very more or less clear there, and this more or less clear there. So what we need to prove is that the decision making is not solely automated, or at least that the consequences do not have a legal effect or significantly similar effect. So what we are actually doing now is we are taking the activities which look like AI and trying to show that they are not having legal effect. For us now, they are not, unless it comes to blocking because of use of anti-cheats. In this case, we have some doubts whether they do have legal effects or not. And in fact, that if we cannot use this argument, and if we fail to show that something doesn't have a legal effect, we try to analyze whether we can show that it's not solely automated and whether like human interaction exists there. I can give an example of what this second scenario could be about. So let's say we have this player relation management program within which we would analyze various activity of our users. It will be an analysis of game statistics. So again, we come to the question of whether game statistics should be considered as personal data. We assume, and because we don't know, that it is personal data. For now, we want to be compliant as much as possible. So the program analyzes game statistics. The program makes some patterns and predictions about what the users would behave like depending on their game statistics. So for example, a user has not played World of Tanks for the last 1 month. And at the same time, this user has spent quite a lot of money during the previous year. Our BI analysis look at some other game statistics measures and show that we still can bring this user back within the next month if we offer quite a good tank, this one, for example. It involves analysis of various data, segmentation of user, and offering of a particular item within the game. But the question is, it wasn't actually artificial intelligence who decided that we should offer this tank. It was a human who made this program working. Is this solely automated decision making under the GDPR? The explanations, the guidelines of Working Party 29 suggest that it could be actually. So this is the balance we are trying to find.
Yeah, an excellent example how our job has changed over the past months. Now in-house lawyers are discussing with the tech people what is a solely automated decision or not, and how to document that it is not a solely automated decision. Willi and Rafael, I think, and also Paulina, I think you are sharing pretty similar experiences. Can you give some insights how you deal with that issue within your companies?
Yeah, sure. Well, I think I agree with Darja's analysis here. But let's take a step back and think about what the GDPR is about and this Article 22, because this is not targeted specifically to our industry. Profiling and automated decision making, it's to protect citizens first, because we've seen many adversarial results of automated decision when you look for a job. when you go to renew your police insurance for surveillance reasons, and access, for discrimination, etc. And this article is all about that, so how you can lose a right or an access to something that anybody else will have to. When you think about just a video game, a casual activity, there is not much that you can say that will very affect the individual on his life. Maybe we have one example that could affect it because it affects your finance. It's when you're banned from a game, permanently banned. So you played, we can use a software, we detect that you're using a booster, that you're cheating anyway, you're banned. The software can ban you directly, without any human activity. When you play a free-to-play game, do you have you lose a right? Are you losing a right? Maybe not, because it's a free-to-play, so you haven't engaged any money, so you can just jump into another game, and so you cheated, so you get what you earned, I would say. But at Activision, so you pay $60, $70 to get access to one game, and you be caught cheating after 2 days, and you're banned definitely. Here it could have a negative effect on you, and so we need to think how this anti-cheat software acts and behave. So, and when we can, and if we have a human interaction at some point, either on the way we set up the software, or either if we have a manual review on all the bans that have been issued, etc. So this is, I think, to my opinion, the only negative effect we have. When we talk about marketing, I don't see that very negative to receive emails or to have push notification. We've talked, sorry, I'm probably start derivating, but from the beginning today, we're talking about business application of AI. But we haven't talked about law enforcement with AI and how. Well, I will deviate to your question. So we can pick that up after. Sorry.
Although the question is about GDPR, but when Russia was copy-pasting this provision into its legal regime, we added a little twist. And in order to conduct automated decision-making with the limitations and exceptions similar to the European ones, the consent that an individual can provide must be in written form, and the form is quite strict. It has to contain the passport number, and it has to be manually signed. So you can imagine what kind of a killer to AI development that could be if that norm worked. What I would suggest is that for many AI applications, it's not Article 22 of the GDPR that's important, it's actually Recital 26 that says that anonymous data is not regulated by the GDPR. And for AI, it's not necessarily personal data that's important. It's not even the data about me, say like metadata about my pictures, from the geolocation of my phone, so anything that is attached to me, although not personal. It's data about people like me. In order to segment me, for marketing purposes mostly, the data doesn't have to be within the GDPR realm. And a lot of the technological advancements would happen within the unregulated field. And it leads to a whole new approach to data protection, because we now supplying an individual with remedies to act if anything goes wrong. The segment, a marketing segment, does not have any remedies at the moment. So there's this whole field of interpersonal data, and it's going to be interesting to see how that develops.
Okay, so I'm in this problematic position that these guys just stole all the clever ideas, so I need to figure something out. We also stole the very clever saying, I want to take a step back. I also wanted to use this verb. It's very good when you talk about presentation, so I need to think about differently. I will speak about a bit different issue that we have, which is connected with AI and with Article 22, meaning the situations, which is quite connected with video games, and I mean the exceptions in which you can actually do the hard profiling. Connie, I know you've got the notes, so could you please read out the exceptions in which you can actually do the hard profiling?
Yeah, I will do this immediately. That's Article 22, Para 2.
Yep.
The exceptions to this prohibition, which we just discussed. First exception is you are allowed to apply automated decisions if it's necessary to perform the contract. Second, if it's authorized by law, of course. Or third, if you get the user's consent.
Okay, and now the situation is, my first question, who can give an example of how was the first part? It's necessary for the performance of the contract. Who has an example of how to do it? That something is necessary. You need to do the hard profiling to do it necessary. I have no idea how to apply this part. Even Article 29, Working Party, only gives examples what doesn't fit into the category, and they don't give a single example how to apply it. And in Poland, for example, the funny thing with anti-fraud issues is that there's only a number of kinds of companies who can do the anti-fraud. So we as a gaming company, for example, we cannot do the anti-fraud check because we are not allowed by law. So the only option we have in Poland right now to check if somebody is doing the fraud thing is to ask him for consent. So we would need to have a checkbox. Can we check if you're not doing a fraud right now? Otherwise, we cannot do the profiling by the automated systems to check if somebody is doing a fraud. So this is this kind of a question. So can I ask you if you're a thief? If not, I will not do anything about you. Okay? And this is one of the
Yeah. Sorry to interrupt.
No,
Thinking out loud here, but talking about the performance of the contract, going back to the anti-cheat, is part of your contract with the user. And depending how you draft your contract in your T's and C's, because part of the contract is to ensure a fair game for everybody.
And the problem here is that until now, we don't know how it's going to work with GDPR, of course. But until now, our regulator, he only knows about literal interpretation of the rules. So he just takes the document and reads out loud the single provision and see if you fit or not.
Yeah,
so that's our main concern, and it was the concern until now, because in many cases with consumer issues, I have a lot of friends who are legal counsels, and they said we created something that was very consumer friendly, but it didn't fit, literally into the provision, and we got into serious trouble. And this is one thing that many people have in mind. If the regulator will be thinking from a broad perspective, of course we are safe, because no one logically thinking would say that doing anti-fraud thing is something against the law. But on the other hand, if we have just a regulator who just looks, it's not in the GDPR itself, this may be some sort, at least, of being feeling not very secure about the situation.
Valid point. To wrap it up quickly at this stage, because it's really a complicated matter for those who do not read the GDPR every day. So, Paulina, you made a very decisive point, I guess. You said, well, before we talk about being in compliance with Article 22, let's try to avoid to get into that trouble. And this is probably something we all need to keep in mind when we talk with our tech folks, that it is not always necessary to have the PII, that we can do a lot and achieve the same with anonymous data. That is an aspect that is overlooked. And I think you will agree that if you go that way, it's even more important to document it properly. So in case of regulatory enforcement, you need to demonstrate that you have given it the right thoughts. Daya, if I may wrap up what you said, you made the point, you made a lot of good points, but one of the most important points was that is it really a solely automated decision, or do I find arguments against that? Because I can also create processes in a way where we have intervention by humans, for example, or where we have good arguments that we do not have a solely automated process. And again, I would say that is decisive for the documentation as well, so to get out of Article 22. And you made the point of the legal effects. You made it, Willy. Also of great relevance, that we need always to consider whether this has an impact on the user, the automated decision, if we are in that playing field. Let's come back to your point, Rafael, the exceptions. And I think you made a very valid point that we need to assume that regulators will enforce the exception rules in a very different way. And I have the impression from what you've said that the Polish regulator takes a rather strict approach. Willy, would you say that the exception of performance a contract, that automated decisions are necessary for the performance of contracts, that, for example, in the UK, we have more room to use this exception? If we draft our terms in a certain way, for example, if we make the argument, as you just said, fair play is a core element of every online game.
Well, yes. So I believe in the process we are now, probably all of us, like building our privacy and GDPR program. We have an obligation to document our reasoning and the decision we are making. So as long as we found a good reasoning and a good legal ground, we have some arguments to show to the regulator that in good faith we decided that the Article 22 or whatever article applies or not to this type of processing. So, and after it will depend who you're going to talk to. If you talk to the French regulator, it will probably have a stricter approach than the UK. Our friend in Poland, the president of the regulation, was the vice president of the WP29, chaired by the French regulator. So he's at a very strict school. But it's very difficult for now to say how the regulator will approach that. So what we know now, that all the guidance provided by the WP29 regulator will be the strictest approach on how GDPR should apply, because they missed a lot of things in the final text. So they asked to have a lot of provision that were taken out during the trilogue. And now with the guidance, they try to re-inject some stricter approach to data protection in Europe in many different ways. So the only thing we can do, it's not just like pray and cross our fingers, but it's also just to document and have like a good legal reasoning behind that, and we can always challenge that. And I'm sure, I haven't told you that before, but I worked for 3 years at the CNIL, so the French regulator, so I sort of know how they can approach it. So if you show good faith, you're in a good hand. If you just waive the Article 22 and say, it doesn't apply, it just applies to healthcare providers, for instance, so you will be in trouble. Obviously, you need to remind when you get done raid by an investigator, it's always in one specific topic, and most of this topic is a complaint from a user. So back to my point on what has a negative effect on the user. So if it has a negative effect, be sure that you will have complaint because the person has been banned. And if you don't have a strong argument behind that to protect that, you're at risk. A player will never complain because he received 300 coins by emails because he achieved the level 25.
Yeah, exactly. You mentioned guidance. For those of you who have not followed the entire GDPR creation process, there is some guidance, a bit of guidance, not that brilliant guidance, I must say, of the Article 29 Working Party on user profiling, a handout of like 40 pages or so. Most of you will know that, but some of you may not know that this guidance paper has just been updated like 6 weeks ago. They added some quite useful comments to the paper, so make sure that you download the latest version if you want to dive into that more deeply. The Article 29 Working Group paper on profiling, you will find it on the internet. One last word on the exceptions thing. Raphael, you mentioned the consent idea. And this is what we often hear when discussing with the regulators about Article 22 and the regulation of AI. Is consent really a valid concept of justifying AI applications, Daya? What do you think? Have you given it some thought?
Yes, sure. But as I've said already, we are not even coming to the question of exceptions, because by now we are claiming that we do not fall under Article 22. If I could a little bit elaborate here on what Willy has just said, it doesn't mean that we just decide that Article 22 doesn't apply and don't comply with anything. We fully follow the advice of documenting everything, in the sense that as soon as you have like even as read that Article 22 could apply, you can already do the data protection impact assessment already at that stage and document it here before you come to the exceptions. So I would prefer not to comment on consent here, but for one thing that we have to communicate to our technology guys all the time. What they're saying is okay, even if it is profiling, just put it into your privacy policy, your lawyers, you can do it. And here we unfortunately have to tell them that privacy policy is not a consent anymore.
But the privacy policy is of course very important, also with respect to AI. What does it mean from a practical perspective? What needs to go into the privacy policy if you apply AI technologies? Have you already started redrafting your privacy policies, and have you been desperate about that? Really?
Yeah, the privacy policy is a constant changing animal because the company is moving. So obviously you need to adapt your policy and what you disclose to user to what you do. I don't have any example, sorry, on how which kind of clause should be like in there, except like the general provision that are under the GDPR you need to disclose and the different purposes you're using the data for. So AI will be one of those. But after it's a case-by-case basis, obviously. So each policy is different from a company to another. Even within same company, you could have different policies applied for different activities, for example, depending how big your company is. Except if you're Google and you decided a few years ago to merge all the policies into one privacy policy. That created a lot of issues for those guys in Europe.
Yeah. What challenges have you experienced when dealing with AI in your privacy policy?
Okay. It's a hard issue because we actually, first of all, we still haven't finished the privacy policy under GDPR. So I'm still not up to date because you need first to finalize all your DPIAs to know what actually you should have in this. I would have 2 comments in this. First comment, a bit referring back to the consent thing. From what Daria just said, it's very visible that no one likes tick boxes. So everyone will do anything to avoid tick boxes by changing the way the data are processed, by changing the way the system works, because no one would be happy by having another tick box in the registration form. And I think this is like a very clear issue. The second thing concerning bit privacy policy, but I would speak a bit broader about this, is the big clash that I have in my mind between all information that we have to provide to the person by GDPR. And this is both privacy policy, but also the information clause that goes when you register on a page, against the whole idea of GDPR that you should be clearly informed about how you work with the data. Because on one side, GDPR says, so there's a list of, I don't remember how many, 15 things which you need to disclose to the user when he registers, for example, on the web page, what you are going to do with the data. What is going to be the retention period? If you use it for different purposes, then what are the retention periods for each of the purpose? So that the user, when he gives the consent, he's informed on how the consent works, to what he consents. On the other hand, if you don't do a video, like a half-an-hour video with somebody explaining what's there, or making like a 10-page book attached before you can click on the content, you actually miss the clarity. Because if I personally would see like half of a page of information what we do with your data, it's the same what I do with cookie policy. I never looked on any cookie policy if it's not the cookie policy that I'm actually responsible for. Because this is just some plain text that I'm not interested in. So this is the big clash, and I think this is one of the biggest clashes we have right now, thinking how to approach the issue to keep the clarity, transparency, which are the core values of GDPR, while being compliant with the direct obligations that are given by the regulator.
I think everyone agrees with that. Daniel.
Thank you for amazing things. We are just facing all of them like every day. One just thing to comment on is that again Working Party 29 requires us to describe the profiling activity even if it is not profiling activity under Article 22. So even if it is not solely automated and even if it doesn't cause any significant legal effects, it's still profiling, and we need to describe all our marketing, in-game offers and so on. And here we come to the question, so not we, our marketing guys come to the question, okay, lawyers, we will describe everything for you, but don't you think that our competitors will do the same from now on? Isn't it our trade secret? It's good that the GDPR provides us with the possibility not to disclose some information because it's trade secret, but the GDPR says it's only in one place, in one recital, and in application to the right of access, not with regard to the profiling issues. So, like, it complicates even more.
I couldn't agree more. Let's read out what the regulator is telling us. As you said, they are telling us, tell the data subject that you are engaging in this type of activity in the broadest sense. That means even if you are of the opinion and if you have documented, as we discussed it, that you not fall under 22, you need to describe what you are doing and disclose what you are doing and describe it precisely. And the regulator is further requiring us to provide meaningful information about the logic involved. Think about what we've heard this morning, how complex AI is and how you want to describe it in a transparent and easy to understand way in your privacy policy, and explain the consequences of processing data in the actual way, and finally give the user, we should not forget that, the option to opt out. That's really a big headache. And this is again something where the GDPR has applied a mechanism that companies just need to disclose what they are actually doing. If they don't do that and use the best effort to do that, they are at risk to be fined, because we should not forget Article 22 is one of the provisions when breached that could be fined with these significant fines under the GDPR, up to 20 million euro or 4% of your worldwide turnover, whatever is the whatever is greater. And that is significant, in particular for our industry, I would say. Really?
Yeah, 2 points on the privacy policy, just to build up on what has just been said. So you have this obligation to give a ton of information on the GDPR. But you have, from a practical point of view, 2 challenges, I guess. First one is how you merge your global privacy policy with the GDPR requirement. First, because the definition of personal data might be different. So are your system exactly the same worldwide, or do you differentiate system? So you can have like different privacy policies that will apply by region, or you can merge everything into one single privacy policy. That would create even more wording and description, because you have other obligations. In South Korea, for example, you have like very long list of what you need to disclose and how you need to obtain consent. Second point, it's simplification and easy information to read. And a few years ago, we've seen the Bavarian authority that it was an opinion, I guess, but required for mobile. So how to disclose a privacy policy on mobile, and it should be very straightforward and very short. So how can you comply with like the 25 pages that CD Projekt is drafting under privacy policy into the mobile game that require, it's just a screen from very, very small screen. So do you want to scroll for 20 minutes before starting playing your game? Or should we deliver a small version of the privacy policy? In that case, we are missing most of the purposes while we are collecting information and what we're doing. And we are probably not disclosing your right, except just saying you have some right under GDPR. So what's the real question is, we need to have internally, so why we want to take the risk. So what would be the best approach? Is it the best approach to satisfy the regulator? Is it the best approach to properly inform lightly our users that they are not stuck under a privacy policy, but can like accept it, can be aware of what we are expecting to do with the information, and then start playing the game, because it's why they are downloading the app for. Not to read like long contracts. And on top of that, we're talking about privacy policy, but you have the T's, the term of uses, etc., that are also within this acceptance at the first screen when you enter the game.
Yeah, I agree, and we should also bear in mind this process never stops. So whenever you apply a new AI technology, you are engaging again with your tech folks, and you need to think about how to address this in your privacy policy and how to justify it and how to document it internally. So it's an ongoing task. So lucky lawyers. I promised to reserve a couple of minutes for questions, and we have a couple of minutes left, 3 actually. So Ross.
Well, you can go quite far indeed. Unfortunately for you, your client, US-only base, were targeting European citizen and European resident will be subject to GDPR with this extraterritoriality clause.
But what does targeting mean?
Well, if you well, we have like in other field like some definition on what's targeting. So, for example, if you're targeting French market, you will be expected to have your website in French, for example. If you sell to the French market, you will be able. You must deliver the information in French. If you have just a website on .com with just the American flag, for example, as a language, but a French user can buy it and will pay in US dollars and will be charged. Will have to convert himself, from his bank account. So you're not targeting here French customers. So this would be out of scope. But if you have an extension on .fr, the website falls under the GDPR.
I think in general terms, from a European perspective, it doesn't need much so that the GDPR applies. So in other words, we successfully exported our data privacy regime to the US.
Right.
So I was reminded that we need to close the panel. I would like to thank all of you for these fantastic and very practical guidance on the GDPR and its implications. Thank you so much, and thank you for your interest. Thanks.